Thank you, Chair. First question to you, Mr. Rahim. Thank you for reminding us about the tragic consequences of the Zamir matter. I'm going to ask you some questions about that, and if you have the answers, it would be much appreciated. To your knowledge, sir, did Mr. Zamir have a criminal record? Okay. To your knowledge, did Mr. Zamir, at the time of the tragic consequences, was he on an interim release already?
He was not.
Okay. And to your knowledge, sir, during the period of time by which he was on bail or judicial interim release, the formal legal name, were there any allegations of breaching of that order or bail?
There were not.
No. So in my view, the system worked as designed. The vast majority of individuals who are charged with criminal offenses, and I would dare say probably in the high 80th percentile, low 90th percentile, are not the type of individuals that we as the Conservative Party are concerned about. We are concerned about repeat violent offenders who are reaping the benefits of a soft on crime liberal agenda. My next question to you, Chief. Chief, for 4+ years, you have been part of a body of law enforcement and leaders right across this country, including premiers, including mayors, including victim advocacy groups who have been pushing this liberal government to change their soft on crime bail laws, all to no avail. You were promised relief under Bill C-48. That did not move the needle one iota in terms of curbing the behavior with these repeat violent offenders. So today, actually last week, we introduced in the House of Commons the Jail Not Bail Act, and today, on one of our opposition motion days, we started to debate that. So I'm going to be asking you some questions and your thoughts on some of the key features of the Jail Not Bail Act. We're wishing to replace the principle of restraint under 493.1 with the principle of protection of the public as the priority in judicial interim release hearings. Do you support that, Chief? Chief.
Yes, sir, Mr. Brock.
I didn't hear the answer.
Mr. Brock, my answer to that is yes.
Okay. We are adding several violent indictable offenses to the list of reverse onus offenses at subsection 515 sub 6 for the determination of judicial interim release. Do you support that?
Yes, I do.
We're going to create a list of major offenses composed of violent reverse onus offenses. Do you support that?
Yes, I would.
We're going to prevent those charged with major offenses from being released after arrest by a peace officer. Do you support that provision?
Could you repeat that?
We're going to prevent those charged with a major offense from being released after arrest by a peace officer. We want those individuals to go to court. Do you support that?
Absolutely. Yes, I do.
We're going to require that only a Superior Court judge on a reverse onus basis, whether to permit the interim release of an accused charged with a major offense while the accused was on release in respect of another major offense, and if the accused was convicted of a major offense in the last 10 years. In essence, treating that class of individuals under Section 469 of the Criminal Code that only a Superior Court justice can entertain the judicial interim release application. Do you support that?
Yes, I do.
Do you support the provision that we're going to provide that on the expiry of the interim release of an accused upon their conviction of an indictable offense while they await sentencing?
One more time, please.
That judicial interim release will not be available to those convicted of an indictable offense pending sentencing.
I agree with that, yes.
Do you agree that prohibiting those with a conviction for an indictable offense in the last 10 years from being named as a surety?
Yes, absolutely.
Thank you.